Hello, everyone. I am Jeannie Fraser Price, the Louis Weiner Jr. Law Library Professor of Law at the Boyd School of Law at UNLV, where I also have the privilege of directing the Law Library. I am delighted to be joined today by my friend and colleague Marketa Trimble, who is the Samuel S. Lionel Professor of Intellectual Property Law at the Boyd School of Law. Professor Trimble is a well-recognized scholar in international intellectual property law. Her work centers on the intersection of, on the one hand, international intellectual property law and conflicts of law and international private law on the other. Professor Trimble is the co-author with Professor Paul Goldstein at Stanford of two leading law school casebooks. One, International Intellectual Property Law, is in its 6th edition, and the other, International and Comparative Copyright Law, was just published this past year. Professor Trimble is also the author of a book on patents and the limitations on their enforceability internationally, namely Global Patents, Limits of Transnational Enforcement, published by Oxford University Press in 2012. Professor Trimble's most recent book, which is the focus of this conversation, the EU Geo-Blocking Regulation, a commentary, was published earlier this year by Edward Elgar and complements her other publications in the area of cyber law. Professor Trimble frequently presents at conferences in the United States and abroad, most recently at the International Conference on Emerging Issues in Intellectual Property Law at the Salzburg University in Austria. She is an elected member of the American Law Institute, as well as of the International Academy of Comparative Law. So Marketa, I am looking forward to learning more about geo-blocking and your new book. I noted that one scholar who had read the book and who had commented so favorably on it remarked that geo-blocking is one of the most promising and perplexing measures capable of addressing the challenges posed by the internet. So I wonder if we might begin by asking you to explain what geo-blocking is, how it's used, what challenges it might help us meet, and how you became interested in it, not necessarily in that order.
Thank you very much, Jeannie, for talking to me today about my book and about my favorite topic, which is geo-blocking. Geo-blocking in general is a technique that large content providers, service providers, other actors on the internet might use to limit access to content on the internet based on their physical location. So we like to think of cyberspace as this wonderful area where nobody knows where we are and everything is somewhere in the cloud. But in fact, we are still physically located in a particular space. And various techniques, mechanisms of geolocation allow these actors on the internet to figure out where users are located. There might be a variety of reasons why these actors might want to block access to certain content. For example, they might try to comply with a certain country's regulations or laws, and those laws and regulations are typically limited to the region, to the geography, to the territory of that particular country. So geo-blocking would allow these actors to block access to, let's say, online gambling or to certain adult content, so that users from the jurisdiction, from the country that doesn't permit this content cannot actually access it. So geo-blocking can be useful in a variety of contexts. I got interested in geo-blocking originally because I work on issues of intellectual property law, including copyright law. And copyright licenses to show, to make certain content available, are often limited by geography. They are limited to certain territory, to certain countries, regions, and therefore content providers will often use geo-blocking to block access. Frankly, it was a friend of mine who once asked me, so if I try to circumvent these geo-blocking tools and mechanisms, am I violating any laws? And I said, well, I'm not sure, probably it depends. So that prompted my initial interest in researching geo-blocking, which I started doing in about 2009. And at that time, very few people actually knew about geo-blocking. But I think today, as we encounter more and more circumstances when our access to content is being blocked on the internet, I think more and more people now understand that geo-blocking exists and is widely used on the internet today.
Even though we might not know what it's called.
Exactly.
So you've talked about some of the beneficial reasons that geo-blocking technology can benefit all of us. Should we be worried about possible misuses of the technology or even unexpected consequences of appropriate uses of the technology?
Absolutely, as all technologies, even geo-blocking might be misused or used for reasons we might not like. Of course, many members of the public don't like the fact that geo-blocking is used even for limiting access for copyright law reasons. People don't understand that these copyright licenses might be limited to certain territories and are upset that they cannot access their favorite BBC show all the time. But that's how copyright law works. But there might be other contexts when this might be problematic. For instance, many internet users might be familiar with price discrimination. So many internet actors, many providers of goods and services on the internet will use geo-blocking to differentiate among consumers, customers in different territories, regions. So it is used to sort of set the prices as high as the market allows, which is perhaps beneficial because it also allows to set prices lower for some consumers. But of course, it also means that sometimes it discriminates among consumers. And that was exactly what prompted the European Union to adopt a regulation against geo-blocking, because the regulators and legislators in the European Union heard from European Union residents about all these instances in which prices would vary, whether they were based or located in Finland or Greece or Sweden or Spain.
So the EU seems to be a much more complicated place to engage with the internet than the United States. I'm wondering, how does this legislation that's been enacted in the European Union impact us in the United States, or does it at all?
So that's a very good question. And often people think, well, surely if Europeans want to take this path, it shouldn't affect us. But in fact, lately, the European Union has been pretty successful at legislating with a significant extraterritorial reach. A good example is the regulation protecting personal data and privacy, the famous GDPR, the General Data Protection Regulation, that applies to pretty much everybody who collects data of European Union residents or processes their data or stores their data. And similarly, this geo-blocking regulation affects anybody, any business, any person, if they offer goods or services to residents in the European Union. So even a company or institution or a university, for instance, in the United States that thinks that they don't really have any presence in the European Union might still be offering goods or services to European Union residents. And those goods and services don't have to be deliverable in the European Union. So it could be, for instance, a university that offers a graduate program to European Union students. Even though those programs will be eventually in the United States, the services are being offered to European Union residents. And so even businesses, persons, institutions in the United States that offer goods and services in the EU have to follow this regulation.
So it seems like it might work the other way too. Is there any need, or is there legislation in the United States that corresponds to this regulation, or is there a need for similar legislation?
Well, it's an interesting question. I think we in the United States are in a little different positions. Let's face it, the Europeans are really trying to build up a single market. So they are trying to combine the markets of all these different, now 27 member states, and create one big internal market, including in cyberspace, internal market. In the US, we don't have this problem. We do have one market that's US-wide. We do have state regulations, but we also have the Dormant Commerce Clause and various legal means to make sure that we don't create new barriers to free movement of goods and services. So we in the United States are, I think, are much more open to the idea that companies might want to geographically limit certain content or geographically limit certain goods and services.
So your book mentions that the EU regulation on geo-blocking makes an exception for audiovisual and electronically supplied services that involve copyright-protected content. Can you talk a little bit about that exception, what prompted it?
So the geo-blocking regulation in the European Union is framed as an anti-discrimination measure. It was not the first regulation in the history of the European Union to address discrimination in providing services. They have an older piece of legislation about non-discrimination in providing services. That older regulation, though, it was a directive, didn't solve all of it, and that's why geo-blocking regulation, the regulation was adopted. But even this older piece of legislation exempted from its scope all audiovisual services. And the reason back then probably was that there were large audiovisual industry players who saw a need for dividing up the markets, for market partitioning, for making sure that they could do staggered release, country by country, and all that. Staggered release, particularly for European motion picture industry, is very important because the co-production mechanisms there really take benefit of staggered release in various markets across the EU. So the audiovisual industry made sure that audiovisual content was exempted from the old piece of legislation. When the geo-blocking regulation was originally proposed, the European Commission that proposes the legislation thought very hard about including audiovisual services in the regulation and prohibiting geo-blocking even in the audiovisual industry. But there was a big pushback from also copyright owners who were concerned that eliminating geo-blocking within the European Union would really complicate matters in terms of copyright law. Because copyright law in the European Union, as opposed to the United States, is still fragmented. In the US, we have one copyright law for the entire country. But in the European Union, each of the 27 countries have its own copyright law. You might have, and you do have, situations when content, the copyright to the content, is owned by different people, different entities in different countries. So geo-blocking is very important in that kind of scenario. So when the regulation was finally proposed and negotiated in the Parliament and in the Council of the European Union, clearly many stakeholders, even the general public, really hoped that copyrighted works, that audiovisual works would be covered by the regulation, that geo-blocking would be eliminated, and Europeans could access their content from wherever they would want in the EU. In the end, it was part of the legislative compromise that copyrighted works were exempted from the regulation, but only in terms of their electronic delivery. So, for example, if you want to purchase a book online, physical book, geo-blocking is prohibited within the European Union. But if you want to buy an e-book, geo-blocking is still permitted. And similarly, geo-blocking remains allowed for all audiovisual services, whether those services are online, as if you want to stream a motion picture, or in physical environments, such as in cinemas.
So this sounds extremely complicated, Professor Trimble, and I'm curious about the structure of your book in terms of explaining the different aspects of the EU regulation.
So the book starts with 2 introductory chapters that I think will be of interest to anybody who wants to learn about geo-blocking, geolocation, and about legal issues of geolocation and geo-blocking. The first chapter is a general introduction that talks about different legal aspects of geolocation, geo-blocking, and also of legal aspects of circumvention of geo-blocking, meaning uses of VPNs, virtual private networks, and other tools.
Are those circumventions legal, or?
It depends. It depends. So that's the introductory chapter number 1. The second introductory chapter explains the path to the regulation. It explains how the European Union became focused on creating the single digital market across the EU and how the geo-blocking regulation fits into that framework. It also talks a little bit about the legislative process, about the different stages. That chapter, I think, will be also very helpful to anybody who wants to learn about the EU legislative process, about the different players, and also about the role of the various stakeholders in the adoption of this regulation. The rest of the book proceeds article by article. Each article of the regulation has its own chapter, and it is dissected and explained in quite a bit of a detail. And I do spend quite a bit of time explaining the legislative process and how we ended up with the particular language in the end. And I think that's very important because as we think about future revisions and amendments to this regulation, people tend to forget what happened in the legislative process and why certain choices were made. So, for example, one article talks about competition law or antitrust issues, and those are very complex. And if you read the regulation today, it might make somewhat of a little sense why the language ended up being the way it is. But the explanation of the legislative process makes it clear that, again, it was a result of a compromise, which, of course, in a political, legislative environment of the European Union is always needed.
So maybe we should conclude by asking you a little bit about the future of geolocation technology. Where do you see the law going? Where do you see the technology going?
Well, I think it's very encouraging that users, the general public, everywhere in the world, and particularly in the European Union, but lately also in the United States, became concerned about privacy on the internet. I think for many years we sort of discounted privacy online, but now I think young people also are very interested in their privacy and personal data protection online. So I think that geo-blocking techniques will continue to improve. Already now we have 3D geo-blocking and geolocation. So not only that they know we are right here at the UNLV TV studio, but they know whether we are on the ground floor or second floor. So that will continue to get even more granular and more detailed. But at the same time, I think we will keep questioning about when we want our location to be known and to what extent. For example, recently, a number of US states adopted laws that limit the uses of geolocation around abortion clinics, which was clearly a reaction to the recent developments in the Supreme Court. And that's a good sign, I think, because it shows that we are much more aware of how our location might be revealing of our choices, of our destiny. And I think it's important that users are aware of that.
Well, thank you very much, Marketa, for joining us today. And thank you to all of you who are watching this video. Professor Trimble's book, once again, is the EU Geo-Blocking Regulation, a commentary. Thank you.
Thank you very much, Jean.